ULP, nature aspects. Q is the commission of unfair labor practice by an employer subject to criminal prosecution? Yes. The second paragraph of Article 247 of the Labor Code expressly so provides. The last paragraph of Article 247 provides that no criminal prosecution for unfair labor practice may be made without a prior final judgment in an unfair labor practice administrative case filed before the labor arbiter of the NLRC pursuant to Article 217, letter A, number 1 of the Labor Code. And even with such final judgment in an administrative case, still, the final judgment would not be binding in the criminal case. Neither would such final judgment be considered as evidence in the criminal case. At best, it would only serve as proof of compliance of the required prior exhaustion of administrative compliance. Discuss in full the jurisdiction over the civil and criminal aspects of a case involving an unfair labor practice for which a charge is pending with the Department of Labor and Employment. Unfair labor practices are not only violations of the civil rights of both labor and management, but are also criminal offenses against the state. The civil aspects of all cases involving unfair labor practices, which may include claims for actual, moral, exemplary, and other forms of damages, attorneys' fees, and other affirmative relief, shall be under the jurisdiction of the labor arbiters. However, no criminal prosecution shall be instituted without a final judgment, finding that an unfair labor practice was committed, having been first obtained in the administrative proceeding. During the pendency of such administrative proceeding, the running of the period for prescription of the criminal offense herein penalized shall be interrupted. The final judgment in the administrative proceeding shall not be binding in the criminal case, nor be considered as evidence of guilt, but merely as proof of compliance of the requirements set forth by law. Article 247 of the Labor Code. Differentiate surface bargaining from blue sky bargaining. Surface bargaining is defined as going through the motions of negotiating without any legal intent to reach an agreement. The determination of whether a party has engaged in unlawful surface bargaining is a question of the intent of the party in question, which can only be inferred from the totality of the challenged party's conduct, both and away from the bargaining table. It involves the question of whether an employer's conduct demonstrates an unwillingness to bargain in good faith or is merely hard bargaining. Standard Chartered Bank, Employees Union versus Confessor. Blue sky bargaining is defined as unrealistic and unreasonable demands in negotiations by either or both labor and management, where neither concedes anything and demands the impossible. Standard Chartered Bank, Employees Union versus Confessor. Q. Article 248, letter D of the Labor Code states that it shall be unlawful for an employer to initiate, dominate, assist in, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or to its organizers or officers. X company has been regularly contributing money to the recreation fund of the labor union representing its employees. This fund, including the financial assistance given by the employer, is used for refreshment and other expenses of the labor union whenever the employees go on a picnic, on an excursion, or holds a Christmas party. Is the employer liable for unfair labor practice under Article 248, letter D of the Labor Code? No. If the contributions of the employer benefit all the employees and there is no employee discriminated against, there is no unfair labor practice. The contributions may be considered a fringe benefit given by the employer. Company A contracts out its clerical and janitorial services. In the negotiations of its CBA, the union insisted that, henceforth, the company may no longer engage in contracting out these types of services, which services the union claims to be necessary in the company's business without prior consultation. Is the union's stand valid or not? The union's stand is not valid It is part of management prerogative to contract out any work, task, job, or project except that it is an unfair labor practice to contract out services or functions performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their rights to self-organization. 248, letter C of the Labor Code. Give 3 examples of unfair labor practices on the part of the employer and 3 examples of unfair labor practices on the part of the labor union. Any 3 from the following enumeration in the Labor Code. Article 248, Unfair Labor Practices of Employers. It shall be unlawful for an employer to commit any of the following unfair labor practice: to interfere with, restrain, or coerce employees in the exercise of their right to self-organization. B. To require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. C. To contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their rights to self-organization. D. To initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizations or supporters. E. To discriminate in regards to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Nothing in this code or in any other law shall stop the parties from requiring membership in a recognized collective bargaining agents as a condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining agreement, provided that the individual authorization required under Article 241, Paragraph O of this code shall not apply to the non-members of the recognized collective bargaining agent. F. To dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code. G. To violate the duty of bargaining collectively as prescribed by this code. H. To pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute, or I. To violate a collective bargaining agreement. Any 3 from the following provisions of the Labor Code. Article 249, Unfair Labor Practices of Labor Organizations. It shall be unfair labor practice for labor organizations, its officers, agents, or representatives to restrain or coerce employees in the exercise of their rights to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. B. To cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. C. To violate the duty or refuse to bargain collectively with the employer, provided it is the representative of the employees. D. To cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for a fee for union negotiations. E. To ask for or accept negotiations of attorney's fees from employers as part of the settlement of any issue in collective bargaining or any other dispute, or F. To violate a collective bargaining agreement. Q. Around 100 workers of a mill in a coconut plantation organized themselves for the purpose of promoting their common interests and welfare. The Workers' Association prepared a petition for increasing the daily pay of its members in compliance with minimum wage rates for the sector in the region and for granting benefits to which they are entitled under the law. However, the workers became restless and anxious after the owner-manager threatened them with mass layoff if the association would press further demands. Most of its members have worked in the mill for 10 to 15 years with no improvement in working conditions and monetary benefits. The leaders of the Workers' Association approached you and asked what legal steps could they take to protect their security of tenure. What advice could you give them? I would advise them to register the Workers' Association with the Department of Labor and Employment, then have the Workers' Association file a ULP case against the employer. Q. A is employed by XYZ company where XYZ's employees union is the recognized exclusive bargaining agent. Although A is a member of a rival union XYR MU, he receives the benefits under CBA that XYZ EU had negotiated with the company. XYZ EU assessed A fee equivalent to the dues and other fees paid by its members, but A insists that he has no obligation to pay said dues and fees because he is not a member of XYZ EU, and he has not issued an authorization to allow the collection. Explain whether his claim is meritorious. No, the fee exacted from A takes the form of an agency fee. This is sanctioned by Article 248, letter E of the Labor Code. The collection of agency fees in amount equivalent to union dues and fees from employees who are not union members is recognized under Article 248, letter E of the Labor Code. The union may collect such fees even without any written authorization from the non-union member employees, if said employees accept the benefits resulting from the CBA. The legal basis of agency fees is quasi-contractual. Del Pilar Academy versus Del Pilar Academy Employees Union. Pablo works as a driver at the National Tire Company, NTC. He is a member of the Malayang Samahan ng Manggagawa sa NTC, the exclusive rank-and-file collective bargaining representative in the company. The union has a CBA with NTC, which contains a union security and a check-off clause. The union security clause contains a maintenance of membership provision that requires all members of the bargaining unit to maintain their membership in good standing with the union during the terms of the CBA under pain of dismissal. The check-off clause, on the other hand, authorizes the company to deduct from union members' salaries defined amounts of union dues and other fees. Pablo refused to issue an authorization to the company for the check-off of his dues, maintaining that he will personally remit his dues to the union. Will the NTC management commit unfair labor practice if it desists from checking off Pablo's union for lack of individual authorization from Pablo? No. Under Article 9481, violation of the collective bargaining agreement, to be an unfair labor practice must be gross in character, must be a flagrant and malicious refusal to comply with economic provisions of the CBA. Alternative answer: no. Checkoffs in the truth impose an extra burden on the employer in the form of additional administrative and bookkeeping costs. It is a burden assumed by management at the instance of the union and for its benefits, in order to facilitate the collection of dues necessary for the latter's life and sustenance. But the obligation to pay union dues and agency fees obviously devolves not upon the employer, but the individual employee. It is a personal obligation not demandable from the employer upon default or refusal of the employee to consent to a check-off. The only obligation of the employer under a check-off is to effect the deductions and remit the collections to the union. Holy Cross of the Bow, College versus Joaquin. Can the union charge Pablo with disloyalty for refusing to allow the check-off of his union dues and on this basis ask the company to dismiss him from employment? No. The check-off clause in the CBA will not suffice. The law prohibits interference with the disposition of one's salary. The law requires individual written authorization to deduct union dues from Pablo. For as long as he pays union dues, Pablo cannot be terminated from employment under the union security clause. As a matter of fact, filing a complaint against the union before the Department of Labor for forcible deduction from salaries does not constitute acts of disloyalty against the union. Tolentino versus Angeles. The collective bargaining agreement between Libra Films and its union, Libra Films Employees Union, LFEU, contains the following standard clauses. 1. Maintenance of membership. 2. Check-off for union dues and agency fees. And 3. No strike, no lockout. While Libra Films and LFEU are in renegotiations for an extension of the CBA, LFEU discovered that some of its members have resigned from the union, citing their constitutional right to organize, which includes the right not to organize. LFEU demands that Libra Films institute administrative proceedings to terminate those union members who resigned in violation of the CBS maintenance of membership clause. Libra Films refuses, citing its obligation to remain a neutral party. As a result, LFEU declares a strike, and after filing a notice of strike and taking a strike vote, goes on strike. The union claims that Libra Films grossly violated the terms of the CBA and engaged in unfair labor practice. Are LFEU's claims correct? 2015. LFEU's claim that Libra Films committed ULP based on its violation of the CBA is not correct. For violation of a CBA to constitute ULP, the violation must be a violation of its economic provisions. Moreover, said violation must be gross and flagrant. Based on the allegation of the union, what was violated was the maintenance of membership clause, which was a political representational provision, hence no ULP was committed. BPI Employees Union Davao versus BPI. A labor union lawyer opined that the labor organization is a private and voluntary organization. Hence, a union can deny membership to any and all applicants. Is the opinion of counsel in accord with law? No. The opinion of counsel is not in accord with law. The Labor Code in Article 249 A and B provides that a labor organization has the right to prescribe its own rules for the acquisition or retention of membership. But it is an Unfair Labor Practice Act for a labor organization to restrain or coerce employees in the exercise of their right to self-organization. Thus, the labor organization cannot discriminate against any employee by denying such employee membership in the labor organization on any ground other than the usual terms and conditions under which membership or continuation of union membership is made available to other members. Q. The day following the worker's voluntary return to work, the company's production manager discovered an unusual and sharp drop in workers' output. It was evidently clear that the workers are engaged in a work slowdown activity. Is the work slowdown a valid form of strike activity? A work slowdown is not a valid form of strike activity. If workers are to strike, there should be temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. Article 212, letter O of the Labor Code. Eagle Star Company required a 24-hour operation and embodied this requirement in the employment contracts of its employees. The employees agreed to work on Sundays and holidays if their work schedule required them to do so, for which they would be paid additional compensation as provided by law. Last March 2000, the union filed a notice of strike. Upon Eagle Star's petition, the Secretary of Labor certified the labor dispute to the NLRC for compulsory arbitration. On April 20, 2000, Maundy Thursday, while conciliation meetings were pending, the union officers and members who were supposed to be on duty did not report for work. Neither did they report for work on April 21, Good Friday, and on April 22, Black Saturday, disrupting the factory's operation and causing its huge losses. The union denied it had gone on a strike because the days when its officers and members were absent from work were legal holidays. Is the contention of the unions correct? The contention of the union is not correct. In the case, it is clear that the employees agreed to work on Sundays and holidays if their work schedule required them to do so, for which they would be paid additional compensation as provided by law. The above-mentioned agreement that the employees voluntarily entered into is valid. It is not contrary to law. It is provided in the agreement that if they will work Sundays or holidays, that they will be paid additional compensation. as provided by law. Neither is the agreement contrary to morals, good customs, public order, or public policy. Thus, when the workers did not report for work, when by agreement they were supposed to be on duty, there was a temporary stoppage of work by the concerted action of the employees as a result of an industrial or labor dispute, because they were on strike. See Interfield Laboratories Employees Union, FFW versus Interfield Laboratories. On the day that the union could validly declare a strike, the Secretary of Labor issued an order assuming jurisdiction over the dispute and enjoining the strike, or if one has commenced, ordering the striking workers to immediately return to work. The return to work order required the employees to return to work within 24 hours and was served at least 8 a.m. of the day the strike was to start. The order at the same time directed the company to accept all employees under the same terms and conditions of employment prior to the work stoppage. The union members did not return to work on the day the Secretary's assumption order was served, nor at the next day. Instead, they held a continuing protest rally against the company's alleged unfair labor practices. Because of the accompanying picket, some of the employees who wanted to return to work failed to do so. On the third day, the workers reported for work, claiming that they do so in compliance with the Secretary's return to work order that binds them as well as the company. The company, however, refused to admit them back since they had violated the Secretary's return to work order and are now considered to have lost their employment status. The union officers and members filed a complaint for illegal dismissal, arguing that there was no strike but a protest rally, which is a valid exercise of the workers' constitutional right to peaceful assembly and freedom of expression. Hence, there was no basis for the termination of their employment. You are the labor arbiter to whom the case was raffled. Decide. Yes, there was a strike, no matter how they call it. The continuing protest rally against the company's alleged unfair labor practices constitute a temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute, a case of strike as defined in Article 212, letter O of the Labor Code. Recently, in Santa Rosa Coca-Cola Plant Employees Union versus Coca-Cola Bottlers Philippines, the Supreme Court clarified that a strike comes in varied forms, from slowdowns, mass leaves, sit-downs, or other similar activities. A protest rally, which result in temporary stoppage of work by the concerted action of the employees as a result of labor or industrial dispute, is clearly a case of a strike. What is the rationale for the state regulation of strike activity, and what are the interests involved that the state must balance and reconcile? The first rationale is the constitutional provision that the right to strike is to be exercised in accordance with law. Another rationale is the Civil Code provision that the relations between employer and the employee are imbued with public interest and are subject to the provisions of special law. A third rationale is the police power of the state. The interests to be balanced are the rights of the workers as primary socio-economic force, to protection of the law, to security of tenure, to concerted activities, etc. These should be balanced with the right of the employer to reasonable return of investment and to expansion and growth. General welfare or the general peace and progress of society should be considered. This is why assumption of jurisdiction and certification to NLRC are allowed in national interest cases. Cite two examples on how the law regulates the use of tire strike as a form of concerted activity. Examples: 1. Procedural requirements should be observed, namely, filing of notice of strike, observance of cooling off period, taking of strike note, and report of the strike vote. Number 2. Use of violence, intimidation or coercion, and blockade of ingress, egress are not allowed. Article 263, letter B, C, F, G of the Labor Code. Johnny is a duly elected president and principal union organizer of the Nagkakaisang Manggagawa ng Manila Restaurant, NMRR, a legitimate labor organization. He was unceremoniously dismissed by management for spending virtually 95% of his working hours in union activities. On the same day, Johnny received a notice of termination. The labor union went on strike. Management filed an action to declare the strike illegal, contending that A. The union did not observe the cooling-off period mandated by the Labor Code, and B. The union went on strike without complying with the strike vote requirement under the Labor Code. Rule on the foregoing contention with reasons. Letter A. Yes. The conduct of a strike action without observing the cooling-off period is a violation of one of the requirements of law, which must be observed. The cooling-off period required by Article 263 letter C and 263 letter F of the Labor Code are to enable the dole to exert efforts to amicably settle the controversy and for the parties to review and reconsider their respective positions during the cooling-off period. But the Labor Code also provides that if the dismissal constitutes union busting, the union may strike immediately. B. Yes. The conduct of the strike action without a strike vote violates Article 263, letter F. In every case, the union or the employer shall furnish the dole the results of the voting at least 7 days before the intended strike, to enable the dole and the parties to exert the last effort to settle the dispute without strike action. Q. A is a member of the labor union duly recognized as the sole bargaining representative of his company. Due to a bargaining deadlock, 245 members of the 500-strong union voted on March 13, 2010 to stage a strike. A notice of strike was submitted to the National Conciliation and Mediation Board on March 16, 2010. 7 days later, or on March 23, 2010, the workers staged a strike in the course of which A had to leave and go to the hospital where his wife had just delivered a baby. The union members later intimidated and barred other employees from entering the work premises, thus paralyzing the business operations of the company. A was dismissed from employment as a consequence of the strike. Was the strike legal? No. The strike was not legal due to the union's failure to satisfy the required majority vote of union membership, 251 votes, approving the conduct of a strike. Article 263, letter F, Labor Code, Section 11, Rule 22, Department Order Number 40-03. Also, the strike was illegal due to the non-observance of the 30-day cooling-off period by the union. Article 263, letter C. Rights of employee to self-organization. Club Filipino versus Bautista. On the first day of the collective bargaining negotiations between rank-and-file Union A and B Bus Company, the former proposed a 45 per day increase. The company insisted that ground rules for negotiations should first be established, to which the union agreed. After agreeing on ground rules, on the second day, the union representatives reiterated their proposal for a wage increase. When company representatives suggested a discussion of political provisions in the collective bargaining agreement, as stipulated in the ground rules, union members went on a mass leave the next day to participate in a whole-day prayer rally in front of the company building. The company filed a petition for assumption of jurisdiction with the Secretary of Labor and Employment. The union opposed the petition, arguing that it did not intend to stage a strike. Should the petition be granted? Explain. Yes, there was a strike. What the union engaged in was actually a work stoppage in the guise of a protest rally. Article 212, letter O of the Labor Code defines strike as a temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. The fact that the conventional term strike was not used by the striking employees to describe their common course of action is inconsequential. What is controlling is the substance of the situation and not its appearance. The term strike encompasses not only concerted work stoppages, but also slowdowns, mass leaves, sit-downs, attempts to damage, destroy or sabotage plant, equipment, and facilities, and similar activities. Santa Rosa Coca-Cola plant employees versus Coca-Cola bottlers. The union contended that assuming that the mass leave will be considered as a strike, the same was valid because of the refusal of the company to discuss the economic provisions of the CBA. Rule on the contention. The union's contention is wrong. A strike may be declared only in cases of deadlock in collective bargaining, negotiations, and unfair labor practice. Article 263, letter C. The proposal of the company to discuss political provisions pursuant to the ground rules agreed upon does not automatically mean that the company refuses to discuss the economic provisions of the CBA, or that the company was engaged in surface bargaining in violation of its duty to bargain, absent any showing that such tend to show that the company did not want to reach an agreement with the union. In fact, there is no deadlock to speak of in this case. The duty to bargain does not compel either party to agree to a proposal or require the making of a concession. The party's failure to agree, which to discuss first on the bargaining table, did not amount to ULP for violation of the duty to bargain. Besides, the mass leave conducted by the union members failed to comply with the procedural requirements for a valid strike under the rules, without which the strike conducted taints of illegality. Union member AA, a pastor who headed the prayer rally, was served a notice of termination by management after it filed a petition for assumption of jurisdiction. May the company validly terminate AA? No, the company cannot terminate AA because the Labor Code provides mere participation of a worker in a strike shall not constitute sufficient ground for termination of his employment. Valid versus illegal strike. Discuss the legal requirements of a valid strike. The legal requirements of a valid strike are as follows. 1. No labor union may strike on grounds involving inter-union or intra-union dispute. Number 2. In cases of bargaining deadlocks, the duly certified or recognized bargaining agent may file a notice of strike with the Department of Labor and Employment at least 30 days before the intended date thereof. In cases of unfair labor practice, the period of notice shall be 15 days, and in the absence of a duly certified or recognized bargaining agent, the notice of strike may be filed by any legitimate labor organization in behalf of its members. However, in case of dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which may constitute union busting, where the existence of the union is threatened, the 15-day cooling-off period shall not apply, and the union may take action immediately. 3. A decision to declare a strike must be approved by a majority of the total union membership in the bargaining unit concerned, obtained by secret ballot in meetings or referenda called for that purpose. 4. In every case, the union shall furnish the Department of Labor and Employment the voting at least 7 days before the intended strike, subject to the cooling-off period herein provided. 5. No labor organization shall declare a strike without first having bargained collectively, without first having filed the notice required, or without the necessary strike vote first having been obtained and reported to the Department of Labor and Employment. 6. No strike shall be declared after assumption of jurisdiction by the President or the Secretary, or after certification or submission of the dispute to the compulsory or voluntary arbitration, or during the pendency of cases involving the same grounds for the strike. 7. In a strike, no person engaged in picketing should commit any act of violence, coercion, or intimidation, or obstruct the free ingress or egress from the employer's premises for lawful purposes, or obstruct public thoroughfares. A division manager of a company taunted a union officer 2 days after the union submitted to the Department of Labor and Employment the result of the strike vote. The division manager said, "Your union threat of an unfair labor practice strike is phony or a bluff. Not even 10% of your members will join the strike." To prove union member support for the strike, the union officers immediately instructed its members to cease working and walk out. 2 hours after the walkout, the workers voluntarily returned to work. Was the walkout a strike? And if so, was it valid activity? Yes, it was a strike because there was a work stoppage by concerted action and there is an existing labor dispute. It was not a valid activity because the requisites for a valid strike were not observed. Can the union officer who led the short walkout, but who likewise voluntarily led the workers back to work, be disciplined by the employer? Yes, the employer may discipline the union officer. An illegal strike is a cause for the union officer to be declared to have lost his employment status. What are the statutory requisites for a valid strike by the workers? Should these requisites be complied with substantially or strictly? Statutory requirements for a valid strike. A. Status of striking union. For a ULB strike or bargaining deadlock strike, only a duly certified or recognized bargaining representative may declare such strike. Procedural requirement. Notice of intent, filing of notice of intent to strike with NCMB. Cooling off period. Observance of cooling off period. ULP 15 days before intended date of strike. Bargaining deadlock 30 days before intended date of strike. Strike vote and filing of the same with the NCMB and the observance of the 7 days strike ban. Cause. The cause of a strike must be a labor or industrial dispute. Compliance with all legal requirements are meant to be and should be mandatory. National Federation of Sugar Workers versus Ovajera. Picket, 2016. Following a deadlock in collective bargaining, the ACAC labor union filed a notice of strike with the Department of Labor and Employment and 30 days later went on strike and picketed the gates of the UP company, paralyzing its operations. The company is engaged in telecommunications, including the supply of cellular phone equipment, with a nationwide network of facilities. In a petition with the DOLE, the company questioned the legality of the strike and asked for compulsory arbitration. The Secretary of DOLE certified the dispute to the NLRC for compulsory arbitration and ordered the company to readmit the workers pending the arbitration. The workers returned and were readmitted by the company, but 5 technicians were temporarily reassigned to the warehouse while 5 others were reinstated on payroll duty. The company justified its acts as an exercise of management prerogative. During the strike, may the striking union picket the company's outside outlets, although they are not company-owned but independent dealers? Peaceful picketing conducted by employees in a strike area during any labor controversy is given protection by the Labor Code. Thus, if the place being picketed is a strike area, which is defined by the Labor Code as the establishment, warehouses, depots, plants, or offices, including the sites of premises used as runaway shops of the employer struck against, as well as the immediate vicinity actually used by picketing strikers in moving in before all points of entrance to and exit from said establishment, then the picketing is protected if it is peaceful. In the question given, however, since the striking union is picketing the company's outside outlets, who are not company-owned but independent dealers, the picketing is not in a strike area, thus the picketing is not protected by this code. President FX, head of a newly formed labor union composed of 1/3 of the total number of rank-and-file employees in Superstores, Incorporated, agitated his fellow employees to demand from management pay increases and overtime pay. His supervisors summoned him to explain his tardiness and refusal to obey regulations. Feeling threatened, he gathered 20 of his members and staged a 2-day picket in front of the shopping mall. Security staff arrived and dismantled the placards and barricades blocking the employees' entry to the mall. In retaliation, FX threw stones at the guards, but the other striking workers just stood by watching him. 7 days after the picket, FX, who had gone absent without leave, returned to the mall and announced that he had filed a complaint for illegal dismissal and unfair labor practice against SSI. SSI learned that FX Group was not registered. No strike vote and strike notice were filed prior to the picket. The guards were told not to allow FX entry in the company premises as management considered him effectively terminated. Other union members were accepted back to work by SSI. Was the dismissal of FX for a valid cause? Was due process observed? There is a valid cause for the dismissal of FX, but due process was not observed. Peaceful picketing is part of the constitutional freedom of speech. The right to free speech, however, has its limits, and picketing as a concerted activity is subject to the same limitations as a strike, particularly as to lawful purpose and lawful means, but it does not have to comply with the procedural requirements for a lawful strike, like the notice of strike or the strike vote. However, in the problem given, picketing became illegal because of unlawful means, as barricades blockade the employees' entry to the mall, and violence ensued when FX threw stones at the guards. There was thus valid cause for the dismissal of FX. However, due process was not observed because SSI did not comply with the twin requirement of notice and hearing. The workers engaged in picketing activity in the course of a strike. A. Will picketing be legal if non-employees of the strike-bound employers participate in the activity? Yes. The picketing is legal even though the employees join it. Picketing is a form of the exercise of freedom of speech. Picketing, provided it is held peacefully, it is a constitutional right. The disputants in a legal dispute need not be employer-employee of each other. De Leon versus National Labor Union. Can picketing activity be curtailed when illegal acts are committed by the picketing workers in the course of the activity? No. The picketing activity itself cannot be curtailed. What can be curtailed are the illegal acts being done in the course of the picket. However, if this is a national interest case under Article 263, letter G, the strike or work stoppage may be stopped by a power of assumption of jurisdiction of the certification of the case to the National Labor Relations Commission. Nagkakaisang manggagawa sa Quezon Hotel versus Libron. Lockout. 50% of the employees of a grandeur company went on strike after negotiations for a collective bargaining agreement ended in a deadlock. Grandeur Company, being a public utility, immediately petitioned the Secretary of Labor and Employment to assume jurisdiction and certify the case to the NLRC. On the fourth day of the strike, and before the DOL Secretary could assume jurisdiction or certify the case to the NLRC, the strikers communicated in writing their offer to return to work. Grandeur Company refused to accept the offer of the strikers because it realized that they were not at all capable of paralyzing the operations of the company. The strikers accused Grandeur Company of illegal lockout. Has Grandeur Company committed the act charged by refusing to accept the offer of the strikers to return to work? Discuss. There is no law that prohibits strikers to decide not to continue with the strike that they have started. Thus, the company committed an illegal lockout in refusing to accept the offer of the strikers to return to work. Under the set of facts in the question, the company did not give the required notice to lockout, much less did it observe the necessary waiting period, nor did it take a needed vote on the lockout. Thus, the lockout is illegal. Assumption of jurisdiction. Calabarzon Transportation Company CTC and the Calabarzon Workers Union CW are parties to a collective bargaining agreement CBA, which is effective until December 31, 1992. The CBA provides for, among others, a bipartite committee composed of CTC and CW representatives to evaluate all positions in the CTC and determine adjustments of wages and allowances. The committee members having failed to agree on the adjustments, the CW filed a notice of strike. Conciliation efforts by the National Conciliation and Mediation Board failed. The CW then declared a strike. The Secretary of Labor and Employment assumed jurisdiction over the dispute and, after proceedings, issued an order awarding certain monetary benefits to the strikers, declaring the strike legal on the ground that CW complied with all the requirements for a valid strike, and C, restraining CTC from taking retaliatory actions against the officers and members of CW who were responsible for the strike. As a lawyer for CTC, what actions should you take? As a lawyer of CTC, I will first file with the Secretary of Labor and Employment a motion for reconsideration. If this motion is denied, then I will file with the Supreme Court a petition for certiorari under Rule 65 of the Rules of Court. I will assail the issuance by the Secretary of Labor of his order and his refusal to reconsider said order as a grave abuse of discretion amounting to lack or excess of jurisdiction. Was the assumption of the labor dispute by the Secretary of Labor and Employment valid? It is valid. Under the Labor Code, Article 263, letter G, the Secretary of Labor has the power to assume jurisdiction over a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to the national interest. CTC, as a transportation company, is in an industry indispensable to the national interest. Was the Secretary's order granting monetary benefits, declaring the strike of the CW legal and restraining the CTC from penalizing CW members valid? The Secretary's order declaring the strike of CW legal and restraining the CTC from penalizing CW members on the basis of the findings of the Secretary that the strike is legal is illegal. He is acting in excess of his jurisdiction. It is a labor arbiter, not the Secretary of Labor, that has jurisdiction to determine the legality of a strike. Article 217, Labor Code, Philippine Airlines versus Secretary of Labor and Employment. The Supreme Court that the Secretary of Labor, when he assumes jurisdiction under Article 263, letter D of the Labor Code, could deal with all the incident of labor dispute, including the issues as to whether or not a strike is legal. Employees of ABC declared a strike after filing a notice of strike with the DOL. They barricaded company gates and damaged vehicles entering company premises. On the second day of the strike, ABC filed a petition with the DOL Secretary to intervene through the issuance of an assumption of jurisdiction order that the Secretary may issue when a strike or lockout will adversely affect national interest. ABC furnished the Secretary with evidence to show that company vehicles had been damaged, that the electric power had been cut off, and equipment and materials were damaged because electric power was not immediately restored. ABC forecast that the country's supply of chlorine for water treatment, which the company produces, would be affected adversely if ABC's operation were closed down by the strikers. Could a DOL Secretary intervene, assume jurisdiction, and issue a temporary restraining order? Yes. The Secretary of Labor and Employment can assume jurisdiction over the dispute because ABC could be considered as an industry indispensable to the national interest since it produces the country's supply of chlorine for water treatment. The assumption of jurisdiction by the Secretary of Labor and Employment has the effect of ending the strike. The strikers will be subject to a return to work order by the Secretary of Labor and Employment upon her assumption of jurisdiction. Effects of assumption of jurisdiction. Following a deadlock in collective bargaining, the AC Labor Union filed a notice of strike with the Department of Labor and Employment and 30 days later went on strike and picketed the gates of the UP company, paralyzing its operations. The company is engaged in telecommunications, including the supply of cellular phone equipment, with a nationwide network of facilities. In a petition with the DOL, the company questioned the legality of the strike and asked for compulsory arbitration. The Secretary of the DOL certified the dispute to the NLRC for compulsory arbitration and ordered the company to readmit the workers pending the arbitration. The workers returned and were readmitted by the company, but 5 technicians were temporarily reassigned to the warehouse, while 5 others were reinstated on payroll only. The company justified its acts as an exercise of management prerogative. Was the certification of the dispute for compulsory arbitration proper? The certification of the dispute for compulsory arbitration was proper. The dispute was causing a strike in an industry indispensable to the national interest. The company was engaged in telecommunication, including the supply of cellular equipment, with a nationwide network of facilities. All these activities are at present indispensable to the national interest. Were the temporary reassignment and payroll reassignment valid? No. The temporary reassignment and payroll reinstatement are not valid. According to the Labor Code, when the Secretary of Labor assumes jurisdiction, such assumption has the effect of automatically enjoining the strike that is taking place, and all the striking employees shall immediately return to work, as the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing before the strikes. In a labor dispute, the Secretary of Labor issued an assumption order. Give the legal implications of such an order. Under Article 263, letter G of the Labor Code, such assumption shall have the effect of automatically enjoining the intended or impending strike or lockout as specified in the assumption order. If one had already taken place at the time of assumption, all striking or lockout employees shall immediately return to work, and the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing before the strike or lockout. The Secretary of Labor and Employment may seek the assistance of law enforcement agencies to ensure compliance with this provision, as well as with such orders as he may issue to enforce the same. The mere issuance of an assumption order by the Secretary of Labor automatically carries with it a return to work order, even if the directive to return to work is not expressly stated in the assumption order. Those who violate the foregoing shall be subject to disciplinary action or even criminal prosecution. Article 264 of the Labor Code. No strike or lockout shall be declared after the assumption of jurisdiction by the Secretary. Savoy Department Store (SDS) adopted a policy of hiring sales ladies on 5-month cycles. At the end of the sales lady's 5-month term, another person is hired in replacement. Sales ladies attend to store customers, wear SDS uniforms, report at specific hours, and are subject to SDS workplace rules and regulations. Those who refuse the 5-month employment contract are not hired. The day after the expiration of her 5-month engagement, Lena wore her SDS white and blue uniform and reported to work, but was denied entry into the store premises. Agitated, she went on a hunger strike and stationed herself in front of one of the gates of SDS. Soon thereafter, other employees, whose 5-month term had also elapsed, joined Lena's hunger strike. The owner of the SDS considered the hunger strike staged by Lena et al. An eyesore and disruptive of SDS business. He wrote the Secretary of Labor a letter asking him to assume jurisdiction over the dispute and enjoin the hunger strike. What answer will you give if you were the Secretary of Labor? I will deny the letter request of the SDS because its business is not indispensable to the national interest. Although the Secretary of Labor has a wide latitude of discretion in deciding whether or not to assume jurisdiction over a labor dispute or certify the same to the NLRC for compulsory arbitration, SDS business is clearly not the one which is indispensable to the national interest. Moreover, the grounds relied upon by SDS, to wit, eyesore and disruptive to its business, betrays the weakness of its case. Several employees and members of Union A were terminated by Western Phone Company on the ground of redundancy. After complying with the necessary requirements, the union staged a strike and picketed the premises of the company. The management then filed a petition for the Secretary of Labor and Employment to assume jurisdiction over the dispute. Without the benefit of a hearing, the Secretary issued an order to assume jurisdiction and for the parties to revert to the status quo until idem. Was the order to assume jurisdiction legal? Yes. The Secretary of Labor and Employment has plenary power to assume jurisdiction under Article 263, letter G of the Labor Code. When in his opinion there exists a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor may assume jurisdiction over the dispute and decide it or certify it to the NLRC for compulsory arbitration. This extraordinary authority given to the Secretary of Labor is aimed at arriving at a peaceful and speedy solution to labor disputes without jeopardizing national interest. Steel Corporation versus SCP employees. Such assumption shall have the effect of automatically enjoining an impending strike or lockout, or an order directing immediate return to work and resume operations if a strike already took place, and for the employer to readmit all employees under the same terms and conditions prevailing before the strike or lockout. Article 263, letter G. Under the same set of facts, the Secretary instead issued an order directing all striking workers to return to work within 24 hours, except those who were terminated due to redundancy. Was the order legal? No. The Secretary of Labor's order will be inconsistent with the established policy of the state of enjoining the parties from performing acts that undermine the underlying principles embodied in Article 263, letter G of the Labor Code. In this case, excepting the employees terminated due to redundancy from those who are required to return to work, which was the very labor dispute that sparked the union strike, the Secretary of Labor comes short of his duty under Article 263, letter G, to maintain status quo, or the terms and conditions prevailing before the strike. In fact, the Secretary could be accused of disposing of the parties' labor dispute without the benefit of a hearing, in clear derogation of due process of law. Jurisdiction and remedies. Lincoln was in the business of trading broadcast equipment used by television and radio networks. He employed Lionel as his agent. Subsequently, Lincoln set up Liberty Communications to formally engage in the same business. He requested Lionel to be one of the incorporators and assigned him 100 Liberty shares. Lionel was also given the title Assistant Vice President for Sales and Head of Technical Coordination. After several months, there were allegations that Lionel was engaged in under-the-table dealings and received confidential commissions from Liberty's clients and suppliers. He was therefore charged with serious misconduct and willful breach of trust and was given 48 hours to present his explanation on the charges. Lionel was unable to comply with the 48-hour deadline and was subsequently barred from entering company premises. Lionel then filed a complaint with the labor arbiter claiming constructive dismissal. Among others, the company sought the dismissal of the complaint, alleging that the case involved an intra-corporate controversy which was within the jurisdiction of the regional trial court. If you were the labor arbiter assigned to the case, how would you rule on the company's motion to dismiss? I will deny the motion to dismiss. Corporate officers, in the context of Presidential Decree 902-A, are those officers of the corporation who are given that character by the Corporation Code or by the corporation's bylaws. Section 25 of the Corporation Code enumerates 3 specific officers that in law are considered as corporate officers: the President, Secretary, and the Treasurer. Lincoln is not one of them. There is likewise no showing that his position as Assistant Vice President is a corporate officer in the company's bylaws. The labor arbiter, therefore, has jurisdiction over the case. Article 217, letter A, number 2. Company A and Union B had a 3-year CBA that expired on June 12, 1990. Negotiations proved futile, so the unresolved issues were referred to an arbiter who rendered a decision on March 15, 1992. Retroactive to December 14, 1990, is the arbiter's decision providing for retroactivity tenable or not? The referral of the unresolved issues of the collective bargaining negotiations to an arbiter is not within the jurisdiction of the arbiter. But assuming that the unresolved issues in the collective bargaining negotiations were properly referred to the arbiter pursuant to the provisions of the Labor Code, that states that a voluntary arbitrator may hear and decide any labor dispute, including bargaining deadlocks, the arbiter's decision providing for retroactivity is tenable. Exercising his compulsory arbitration power, the arbiter could decide the issue of retroactivity in any way which is not contrary to law, morals, good customs, public order, or public policy. But in the case of Manila Electric Company versus Secretary of Labor Reynaldo Kizumbing, the Supreme Court said that an arbitral award shall retroact to the first day after the 6-month period following the expiration of the last day of the CBA that was being renegotiated. Mario comes from a family of coffee bean growers. Deciding to incorporate his fledgling coffee venture, he invites his best friend Carlo to join him. Carlo is hesitant because he does not have money to invest, but Mario suggests a scheme where Carlo can be the chief marketing agent of the company, earning a salary and commissions. Carlo agrees and the venture is formed. After 1 year, the business is so successful that they were able to declare dividends. Mario is so happy with Carlo's work that he assigns 100 shares of stock to Carlo as part of the latter's bonus. Much later, it is discovered that Carlo had engaged in unethical conduct which caused embarrassment to the company. Mario is forced to terminate Carlo, but he does so without giving Carlo the opportunity to explain. Carlo filed a case against Mario and the company for illegal dismissal. Mario objected on the ground that the labor arbiter had no jurisdiction over the case, as it would properly be considered as an intercorporate controversy cognizable by the RTC. Further, Mario claimed that because Carlo's dismissal was a corporate act, he cannot be held personally liable. As the labor arbiter assigned to this case, how would you resolve the jurisdiction question? The labor arbiter has jurisdiction over Carlo's illegal dismissal complaint as he was hired by Mario on a salary and commission basis. In Gripa Life versus Judico, it was held that a worker who is paid on a salary plus commission basis is an employee. While regular courts have jurisdiction over Mario's corporate act of severing ties with Carlo, the labor arbiter, pursuant to Article 217, letter A, number 2 of the Labor Code, has jurisdiction over Carlo's illegal dismissal complaint. Alternative answer: Carlo is party to a joint venture, hence he is not related to Mario as an employee. As a business organization, the affairs of the joint venture are not governed by labor law, except in relation to its employees. Any issue arising from that affair, therefore, must be brought to the RTC. Thus, the NLRC has no jurisdiction because the matter did not arise from employer-employee relationship, and the issue between the disputant is not resolvable solely through the application of labor law. What is the rule on personal liability of corporate officers for a corporate act declared to be unlawful? Corporate officers are not, as a general rule, personally liable for the corporate acts they performed in behalf of the corporation they represent. They are, however, personally liable for their corporate acts if they acted with malice or bad faith. Gurley Eco versus Systems Technology Institute.